Vicarious liability means the master is liable for the torts of the servant. However, the servant must be acting within the scope of the relationship with the master. The act giving rise to the tort must serve the purpose of the master. In agency language, the agent committing the tort is acting on behalf of the principal, and the principal can be held liable for the acts of the agent. Employers are vicariously liable for torts committed by employees when within the scope of employment. Intentional torts are generally not within the scope of most forms of employment, but could be within the duties of a person employed perhaps as a nightclub bouncer. The nightclub could be held liable for a battery by an employee bouncer. As a general rule, companies are not liable for the torts of the independent contractors they hire. The exception here is in the case of a landowner such as a store owner and an invitee such as a customer. If the customer is injured by the independent contractor working in a store or facility open to the public, then the owner of the property can be held vicariously liable. A car owner is generally not vicariously liable for the torts of the driver. The exception is a situation where the driver is working for or somehow acting as an agent for the owner of the car. Parents cannot be held vicariously liable for the acts of their children. When children commit torts, however, the parent can often be held liable for negligence. This is negligence of the parent in enabling the child to commit the tort. This is not a vicarious liability situation, as the child is not the tortfeasor. The tortfeasor is the parent in these cases.